Good morning, everyone. My name is Charbel Barakat. I'm the Vice President of the Tampa Bay Lawyers Chapter. You may remember me from such panels as ESG. What's the deal with that? I hope you enjoyed that. It was a really successful day yesterday, and I think especially the discussion between Chief Justice Muniz and Chief Judge Pryor, moderated by Judge Luck, was really just tremendous, and really got not just an insight into the workings of the courts, but into the human beings that those gentlemen are. And for me, it was a really incredible insight. So thanks to the team that put that together. But today, I'd like to thank you for joining us for our third panel of the conference, entitled "The Post-Pandemic Legal Landscape and the Next Crisis." Remember COVID-19? Some ways it seems like ancient history, especially here in Florida. But it's still very much with us, and the consequences, both in terms of law and policy, will be with us for a long time. And I think this panel will focus on the lasting impact of the COVID-19 pandemic on law and public policy, and how such impact will shape state and federal government response to the next crisis. Our panelists will address such topics as the FDA, CDC, and public health regulation, education policy, vaccine mandates, mandatory lockdowns and shutdowns, and PPP and other COVID-19 relief programs, included related fraud investigations. Almost 3 years on from where the first mass shutdowns took place, COVID fatigue has certainly set in. The Biden administration has quietly begun to wind down the last of its major COVID-era restrictions. The major newspapers have stopped publishing case counts on page one. Mask and vaccine mandates are slowly receding. And the head of the largest national teachers union has asserted she was never in favor of closing schools in the first place. When it came time for organizing this panel, we searched high and low for someone willing to defend many of these COVID-era legal and policy restrictions, and couldn't find someone willing to do it. So instead, we found an all-star panel of folks who've experienced several different aspects, engaged with law and policy from the professional and the personal, and I think hopefully will give you in a relatively short time a really broad but thorough overview of all the different ways in which COVID touched our lives and touched the law, and hopefully some lessons learned for the future. As George Santayana famously said, those who cannot remember the past are condemned to repeat it. Another crisis will surely come, and it is important to lay the legal and political groundwork to make sure we handle that crisis with the lessons learned from this one. So, one last time, let's remember the pandemic. With that, let me introduce our panel's esteemed moderator, the Honorable Rodolfo Armando Ruiz II. Rudy Ruiz is a district judge of the United States District Court for the Southern District of Florida. Prior to his judicial commission on May 3rd, 2019, Judge Ruiz was a circuit court judge for the 11th Judicial Circuit of Florida from 2014 through 2019, and a Miami-Dade County Court judge from 2012 through 2014. Judge Ruiz also served as an assistant county attorney with the Miami-Dade County Attorney's Office and an associate with White & Case, LLP. Judge Ruiz received a Bachelor's of Science in Economics from Duke University, go Blue Devils, and earned his Juris Doctor from Georgetown University, go Hoyas. After graduating from law school, he was a law clerk to the Honorable Federico Moreno of the United States District Court for the Southern District of Florida. Let's welcome Judge Ruiz and the panel with a round of applause.
Thank you, Charbel, for that kind introduction and for putting together this team. I know I speak for all the panelists when we really appreciate your leadership throughout the years, not only for the Federalist Society, but all the dedication you've put towards getting all of us together to share some important perspectives. As Charbel mentioned, I'm here today, and it's really my pleasure to moderate such an excellent panel. And I'm joined by four distinguished speakers. who've all really served on what I like to call the front lines, if you will, of the COVID wars for years that they've lasted, these last 3 years or so. And they really have contributed greatly to legal, social, and public policy battles that were waged throughout the pandemic. And so today, our hope is that we will get a chance to share with you some of the invaluable lessons that each of these folks have learned in their respective arenas firsthand. And it's not only to recognize, of course, some of the challenges that we've overcome, and certainly, as Charbel mentioned, even though it seems that we have turned the corner for good, the specter's always out there. It depends on the tide. Sometimes we hear a little bit more of some of the restrictions that we've been dealing with over the past few years come back, and depending on different states and your perspective, we still have many lessons to learn, and we have still a lot of policy to confront over the coming years. And so our goal today really is to take a moment to reflect on the lessons we've learned and frankly, to be better equipped to the extent we have a similar challenge in the future. So today with us, we have Jay Trezevant, Jordan Pratt, Brett Shumate, and Karol Markowicz. And I'd like to share some of their bios with you briefly, just to show you what a great group we have. So Jay is an assistant United States attorney in the United States Attorney's Office for the Middle District of Florida, where he has served with distinction in the Tampa Division since 1997. And over that span, Mr. Trezevant has participated in criminal and civil fraud matters in cases that have returned over $1 billion to government programs. Currently, he works in the economic crime section, prosecuting a wide array of complex investigations in cases involving economic crimes, such as healthcare fraud, securities fraud, tax fraud, money laundering, mail and wire fraud, and cases concerning public corruption. At the end of our lineup down there, we have Jordan Pratt, who's a senior counsel at First Liberty Institute and works in its Washington, D.C. office. Before joining First Liberty, he served in various roles in both state and federal government as senior counsel in the United States Department of Justice, deputy general counsel in the U.S. Small Business Administration, and Deputy Solicitor General in the Florida Office of the Attorney General. And at the Department of Justice, Jordan advised the White House on judicial nominations. And as a Florida Deputy Solicitor General, he represented Florida in both state and federal courts. Brett Shumate is a partner at Jones Day in Washington, D.C., with a practice focusing on regulatory litigation. At Jones Day, Brett has represented the Alabama Association of Realtors in a successful challenge to the CDC's eviction moratorium in the Supreme Court. He joined Jones Day in 2019 from the Department of Justice, where he served as a Deputy Assistant Attorney General for the Civil Division's Federal Programs Branch. And last but not least, Karol Markowicz is a weekly columnist at the New York Post and Fox News, contributing editor at the Spectator, and a contributing writer to Washington Examiner magazine. She's also written for the Wall Street Journal, USA Today, Newsweek, Time, Jewish Forward, National Review, Daily Beast, Business Insider, and many other publications. She appears regularly on Fox News and Newsmax, OAN, and Fox Business Network, and is featured frequently on national radio programs. So as you can tell, we have folks that are coming at the COVID pandemic from anything from civil liberties and religious liberties to education policy to criminal law. And so I'd like to start with Jay and your perspective, and it's perhaps one that our audience, I think, may not fully appreciate, given that it primarily focuses on the pandemic's impact on our criminal justice system. And indeed, in preparation for today, and Jay, we spoke about this, I went back and looked at my criminal docket and noted that in just the last 10 months or so, I think I've repeatedly dealt with wire fraud cases involving the Paycheck Protection Program, which was an SBA-backed loan program that, as many remember, was designed to help businesses keep their workforce employed during the COVID-19 pandemic. And I know you've handled these types of cases in your everyday practice, Jay, since the onset of the pandemic, not to mention other forms of white-collar crime that's been generated by the programs that we put in place to address the economic consequences of COVID-19. So I'm wondering if you could share with our audience and address the post-pandemic legal landscape in terms of criminal prosecutions and what you're seeing in particular as an assistant United States attorney in the Middle District of Florida.
Thank you very much. Just to give you a little bit of scale and understanding of how we approach these type of programs. When I think of government programs, I often have to explain it to people. How do they work, and where do we fit into the into the whole picture? the best way to think of a government program, and it's a little scary for some people, is when I was a kid, when a lot of y'all were young, you'd go door to door on Halloween, you'd knock on the door, they'd open the door, they'd give you a piece of candy or put out a tray, you'd take one, you'd take it, and you go to the next house. Inevitably, there was always some house where the people weren't home. There was always some house that put the tray out and had a little card that said, please take one. My wife told me on the way over here this morning that those were the Snyders in her neighborhood. And they would put the tray out and they would say, take one. And most kids would take one. Some kids might take two. But inevitably, there would be the one kid who would just clean the tray out. And so when I think of government programs, that's how it works. Somebody's come along, they clean the tray out, and I usually get called in my office by an agent after the tray's been stolen. So that's how it really works for me. So when you think of the PPP program, right, you look at a program, the first set aside of money for the PPP loan program was $350 billion. The next one was $310 billion. Ultimately, it was $813.7 billion set aside for that program and that program alone. And I went and pulled some data and information to hopefully give you this morning that will make some sense and give you the scale of what we're looking at. So May of 2022, the Inspector General, SBA Inspector General, put out a report. And in that report, the Inspector General compared just the PPP program, which is an SBA 7A loan program, to the immediately preceding year, 2019. They went and looked at 2019, all of the SBA 7A loans for that year. So just so you can understand, the SBA 7A loans for fiscal year 2019 put out about 52,000 loans that generated 52 complaints that were then followed up and investigated by the SBA. The PPP program, that one 7A program, had 11.4 million loans. Those 11.4 million loans, as of December 2021, had generated 54,000 complaints. So an increase on an order of a magnitude of over 1,000. They also went and they looked at the loans for the first 6 months, pulled the SBA data for the first 6 months, and what they found was that when they applied an algorithm looking for likely fraudulent loans, duplicate loans, loans where the individuals had applied for the loans for the business, and there in fact wasn't a corporation in that state for that year. So likely loans, they identified about 70,000 in the first 6 months that were likely fraudulent loans. Of that, that was about $4.6 billion of the money that had gone out the door. Now, if you take the 54,000, there's an apples and oranges and bananas math, but if you take the 70,000 loans, assume they're all fraudulent, and you take the 54,000 complaints, that's like 125,000, right? 124,000. You're talking about 1% of the loans. I'm here to tell you that as an assistant U.S. attorney who's done this for over 25 years, if it ends up being 1%, we're all really, really fortunate. I just can't imagine that. So you're talking about a tremendous volume, like nothing we've ever seen before. So how do we meet that middle district of Florida? We're fortunate in middle Florida. We're an extra large district. We span from Jacksonville to Fort Myers. We go across the strait like a sash. I think we cover more than half the counties of in the state, certainly over 11 million people. At the time, we had a terrific U.S. attorney. We have one now. We're always have been fortunate historically in that regard. And we are an aggressive district. We punch above our weight for the number of AUSAs. We bring more cases than pretty much any other district for white-collar fraud. So what we did was we immediately started putting together a COVID-19 fraud task force with the FBI that was joined by IRSCI, Secret Service, HHS, Office of Inspector General, and we formed a working group. And I mean, we formed a working group in March of 2020. The minute they said pandemic, we formed a working group. And that working group and task force involved all the different component federal agencies, state agencies, local law enforcement to identify, investigate, and prosecute fraud cases. We also formed a very specific SBA loan fraud working group that brought in the SBA folks from DC so that we could, because there were new programs with new forms and new applications, we had to understand just how the loan programs were going to work. So those were the challenges that we had to meet. And so by bringing the SBA in and by bringing in all the different component parts, we were able to get a working group together with points of contact that allowed us to reach from the federal to the state, all the way down to every single investigative. Anybody who had a notepad and a car that could go investigate anything, a computer, was involved in these investigations. And while I would like to tell you that we've been able to investigate and prosecute all of these people, we just don't have the resources. We're never going to have those kind of resources. So inevitably, we have to investigate and prosecute representative folks. But like, for example, we investigated one group. It was just a fellow in his house with his wife and his kids. They filed about 50 or 60 fraudulent loans, right? And so now they're in prison, great, but that's one. Think about the numbers I told you earlier. So that's what we're dealing with. Now, luckily, they've extended the statute of limitations out for 10 years for SBA loan fraud programs. So I can tell you right now, we're going to be busy for the next decade working on those. In our civil division, because we always work complementary in Middle Florida, we have a very good working relationship between the civil, the criminal, and the asset recovery divisions. Our civil division early on sprang up in the working group and was swatting down the frauds as they would show up, the people pushing all those bogus health and safety supplies. So in just one case, we call it Zero Store, our civil division used 18 U.S.C. 1345 freeze and injunction powers, pursued an action that swatted down one group out of Vietnam that had formed 300 websites that were selling health and safety supplies that had gone scarce. So rubber gloves, masks, hand sanitizer, but they really weren't selling anything. They were literally just selling nothing. They were gathering credit card information and payments so that they could engage in other fraudulent activities. So in that one action, 300 websites came down. Our asset recovery side, asset recovery division, we were recovering tens of millions of dollars. But still, we've only brought probably about, I think it's something like 52 individuals and groups have been prosecuted to date. But we're going to be prosecuting hundreds and hundreds, and it will increase over time because we're now getting all the documents and the loan applications, and that's what we're going to be facing for literally the next 5 to 10 years. We're going to be making these cases.
Thank you for that insight, Jay. I will tell you that I'd rather have the guy that gave the tray than the one that gave the pennies. I don't know if anyone ever had pennies or raisins were the two that I was a big fan of when you could take everything, including the tray. But I think, it's an apt metaphor because at the end of the day, I know we're seeing it and Jay's in the front lines of it. The reality is that the fallout will be with us for quite some time, understanding the limitations we had at that time and wanting to help earnest businesses keep their payrolls. I think this is just a function of programs that are, as we say, trust-based programs without the oversight you have to patrol them. And so we have to acknowledge that that's going to be lingering with us for better or for worse for quite some time.
Right, without a lot of known and foreseeable moral hazard of bad behavior.
Yeah, absolutely. So I want to turn to a little bit of a different perspective. Jordan, you have truly worked, I think, in a very fast-moving and challenging arena that has been an outcropping or generated by the pandemic. And that's really a focus on federal overreach and concerns over the separation of powers, in particular with civil and religious liberties due to the pandemic. And I know as senior counsel for First Liberty, you've litigated in this space and had really a front row seat to what I have really turned to, and I have talked about this, as stress and a strain in the system in terms of federal power, whether that's violations of basic religious tenets and a view of religious liberty as a second-tier right, or simply executive overreach when it comes to public health. And of course, that could be either implementation of mask or vaccine mandates. I know First Liberty has been navigating these issues for quite some time. So I'm wondering if you could share with our audience a bit of insight into the types of cases you've handled, and really where do you see us going from here, in particular, perhaps with free exercise jurisprudence?
Sure, happy to do it, Judge. So, kind of picking up on the theme from Jay's remarks, I think the cookie jar was sitting out there for government too. It wasn't just folks who were applying for loans, and there was an immense temptation, I think, during the pandemic. Maybe some for truly benevolent reasons, but maybe some for less than benevolent reasons, for government to exceed the scope of its rightful authority and to infringe religious liberty. So I guess the thesis of my remarks is that the pandemic prompted, just numerous violations of very basic, particularly religious liberty guarantees. And that these violations, I think, were symptomatic of a separation of powers out of whack. Furthermore, I think that in terms of the lingering effects, I think we're still seeing some bad habits, at least from certain jurisdictions, that I think we can really trace back to the pandemic. So we'll see if you all agree. I'll sort of offer 4 cases as much as I can in my allotted time and see if that sort of proves the pudding. So the first case that I'll mention is the On Fire Christian Center case out of Louisville, Kentucky. Each of these cases I'm going to talk about a different level of government to kind of show the scope of the problem. But in this particular case, we're dealing with a city government. The mayor for Easter 2020 came out and made an announcement. He said, look, COVID is bad. We're really concerned about it. So you can't have Easter, right? And not even a drive-in service. I don't care if your windows are up, if you're parked in the parking lot of the church, if your pastor is in like a plexiglass box, you just can't do it. It's too dangerous, okay? But, by the way, we're still allowing drive-in liquor sales, right? Bold strategy, right? One of the most basic, sort of well-established and long-standing areas of free exercise jurisprudence is whatever the free exercise clause might mean, at a bare minimum, it means that you cannot discriminate against religious activity, right? And sort of the case that first comes to mind is the Lukumi case, right? This is where the city of Hialeah, had banned what they termed animal cruelty, but it was really targeted at, the Santeria religion, right? And the Supreme Court, I believe it was a Justice Kennedy opinion, said, look, even though on its face this regulation might pretend to be neutral and generally applicable, it's in fact targeted at religious activity, and you just can't do that, right? If the free exercise clause means anything, hopefully it means more than that, more than equality, but at a bare minimum, it means you can't treat religion worse than everything else, okay? And that's been well established for decades. But all of a sudden, the pandemic hits, and we just forget that very most basic guarantee, such that the mayor of Louisville really thinks that he can stand up and ban Easter, like literally to criminalize Easter, with the city police to say, look, we're encouraging people, if anybody violates this restriction, because we know that like Christians are going to want to go out and celebrate Easter. They've been doing it for like 2,000 years. We hear it's a big deal. Something happened, Resurrection Sunday, but this year you just can't do it. And we know some people are going to, so we're encouraging you, let us know if your friends, your family, your neighbors are going to church, because we're going to pay them a visit and hit them with a fine, right? So that was actually a First Liberty case, and I think that was the first, church closure case among many, and many organizations, of course, took these cases. But then District Judge Justin Walker, in a wonderful order spanning, I think it was like 13 or 23 pages or something, just walks through the history of why we even founded our country, right? Those freeing religious persecution, right? Braving, a 9-month voyage, starvation, just so that they could attain religious liberty and exercise their faith. To be told, to tell citizens of that country that you cannot go out and celebrate Easter in your car with your windows rolled up, but if you want to get liquor down the street, go ahead. That's just beyond the pale, right? So there was a temporary restraining order granted in that case, and I think it was even without notice to the defendant because it was on the eve of Easter and the announcement had been made so quickly. But we started to see sort of this unequal, this disparate treatment, sort of theme pop up again and again. So the next case, so we talked about local government. Now we're going to talk about state government. Roman Catholic Diocese against Cuomo, right? The governor of New York comes out and says, look, we're having COVID cases that are spiking in certain areas of New York City. And in any red or orange zone, we're going to limit religious gatherings to either 10 or 25 persons. But by the way, if you're a movie theater, a shopping mall, hair salon, parking garage, whatever, we're not going to have those restrictions, right? And these are policies that expressly categorize on the basis of religion. Unlike in Lukumi, right? At least Hialeah was trying to hide it, right? Like, yeah, we don't like Santeria, we don't like animal sacrifice, we find their religious practices distasteful, but we're really just we're just going to prohibit all animal sacrifice, religious or not. Just pretending that that there's some category of non-religious animal sacrifice. But here, the governor of New York just comes out and says, you're a synagogue, you're a church, you're a mosque. Sorry, you can have 10 people, right? Good luck giving communion to a Catholic parish of 1,000 persons. Do you have to have like 100 masses? I guess that's what you have to do. So anyway, so that gets challenged, and the Supreme Court strikes it down and reiterates that it has been well established for decades that you can't treat religion with disfavor, at a minimum, right? A lot of the action on free exercise jurisprudence right now is about the issue of exemptions, right? To what degree should employment division against Smith be limited and perhaps even overruled? We have statutory protections, on the exemptions issue, like the federal RFRA, the state RFRAs. That's sort of where the action has been in religious liberty until COVID. COVID, we had to relitigate decades of free exercise jurisprudence. So that was the Roman Catholic Diocese case. And then next comes Tannen against Newsom. Tannen against Newsom dealt with California's COVID restrictions, which, among other things, limited at-home gatherings to only 3 households. But of course, in any secular business, theaters, hair salons, again, it's the same thing, right? There was no such limitation. And Tannen dealt specifically with that restriction as it applied to in-home Bible studies, right? Folks who wanted to continue their Bible study practices at private homes were being told, you have to carve off half your Bible study. You can't meet together as a group anymore. But if you want to go, grab drinks at the local bar, have at it. And the Ninth Circuit continued to uphold every iteration of California's COVID restrictions, which had, a palpable, discriminatory impact on religious activities, until the Supreme Court finally, in an emergency posture again, had to step in and say, look, we really meant what we said in Roman Catholic Diocese, and for that matter in Lukumi, and for that matter in all the cases that preceded Lukumi, that you can't treat religion with disfavor. They spelled it out a little bit more in Tannen. The Supreme Court said, you cannot treat any comparable secular activity more favorably than religious exercise. That's what it means to discriminate, against religious activity in the context of free exercise, right? So, again, there were other cases. I'm sort of just giving you the highlights, but this was a widespread problem. So that's at the state level. Okay, so we talked about local, and we talked about state. 2 states, New York and California. Okay, now let's talk about the federal level. This is another First Liberty case. The military, acting pursuant to an executive order, all of the branches of the military, rolled out vaccine mandates for armed service members. And expressly in these policies, they carved out exemptions for folks who participate in vaccine trials. They said, look, you have to be vaccinated if you want to be a member of the armed services, unless you're in a vaccine trial, which is very interesting because by its nature, a trial has a control group, right? People who don't get vaccinated. So, the military's policy was expressly exempting from its application some individuals who had no vaccinated immunity from the COVID-19 virus. And in addition to that, various Navy officials were coming out and bragging about the fact that although the policies announced the possibility of religious exemptions, we haven't granted any, right? We've granted 7, medical accommodations to the vaccine mandate, but no religious accommodations, 0. And that's interesting because the Federal Religious Freedom Restoration Act requires that for any federal government action that substantially burdens religious exercise, the government has to demonstrate that the application of that burden to the particular person who's being burdened, meets the strict scrutiny standard. It's compelling interest, least restrictive means, right? And that's the statute, right? And it's well established that the statute has application in the federal employment context, including to the military. There are various cases that have applied RFRA to the military. So First Liberty brings a case on behalf of, I believe it was 35 members of the Special Operations Community for the Navy, 26 Navy SEALs, some SWICs. I forget what that term is. I think it's swift boat something, but they do some pretty slick stuff. And all of our clients, had lodged, religious accommodation requests. For most of them, their religious objection was that the vaccine had been developed using cell lines that were derived from, aborted fetal cell lines from the 70s. And we had Protestant, Catholic, and Eastern Orthodox Christian clients who had a moral objection, and that was the most common one, a religious objection. And what we discovered during the case was something that was both surprising and non-surprising. The Navy actually had this document. It was the 50-step guide on how to deny a religious accommodation request, right? And only at step 35 is the request even read. And by that time, it was at least by step 12 or something, the denial had already been written. Okay, so it's at step 35 that we read the thing. And then we tweak the denial template to kind of parrot some language, from the request. But what ended up happening is, and we knew that this was the case because all of our clients' denials as they started coming in, they were exactly the same, like word for word. I think they changed the name, like Dear Mr. So-and-so, right? But other than that, it was the same letter. And again, on the theme of basic religious liberty guarantees, the thing that RFRA guarantees at its most basic core is a right to have your religious exemption request individually evaluated. Doesn't necessarily mean you're going to get it, right? But there's a pretty stringent test that the government has to meet, and it has to meet it as applied to you in particular, right? If the government can't even show that it's individually assessing requests, it flunks. It flunks RFRA, out of the gate. And that's in fact what the court held, that the Navy's accommodation process was, quote, theater, right? We had the smoking gun, but we also had all of the denial requests that were the exact same. So res ipsa loquitur, you might say, right? But anyway, so that's what the federal government was doing. Okay, and then I guess I'll conclude, because I know that my time is short. Separation of powers, right? I think a lot of times when we see just really rampant and egregious violations of individual liberties, it's symptomatic of a larger problem. And that larger problem is usually a separation of powers out of whack. And just on the federal side, I'm not qualified to speak on every state's, individual allocation of powers between the different branches. That's often going to be an individual state-specific thing. But, at least on the federal side, we saw in the OSHA case, the Supreme Court made very clear that in rolling out, a vaccine mandate for 84, million Americans. Actually, no, it was more than that. That was the, that's right. That was the federal vaccine mandate, the federal employees. No, for the 100 employees private sector mandate, right, for mandating that over half the country be vaccinated, basically, OSHA had far exceeded its statutory authority, right? OSHA rolled out an emergency temporary standard without any notice and comment, and it was a power that it had only exercised, 9 times in the past. 6 times, it had been challenged, and 5 times it had been invalidated. Only once had it ever been upheld, and never anything like this never had OSHA attempted to regulate what was essentially not a workplace hazard, but as the Supreme Court said, just a hazard of daily life, right? It was just beyond the pale. It was an exercise of federal power that flunked the major questions doctrine, right? That's really what the Supreme Court applied in that case. If Congress was going to authorize OSHA to require everyone to undergo a medical procedure, not for a workplace hazard, but just for a hazard that all of us face in our daily lives, we expect Congress to say so very clearly, right? And here, OSHA had clearly overstepped the bounds of the authority that had been conferred to it by statute. Okay, and the last thing I'll say, lingering effects. You heard me say at the beginning that this is something that hasn't really gone away, at least in some jurisdictions. And I'll tell you an example. Another First Liberty case. New York recently enacted a statute in the wake of the carry decision, the firearm carry decision from the Supreme Court. And the statute basically enumerates the list of all the places where we're not going to allow you to carry a gun, right? And the mayor even came out and said this, like, we disagree with the Supreme Court, we think it's wrong-headed, so we're going to do everything we can to basically try to walk this back, which is a bold strategy, right? If you're going to be, enacting something that's going to get litigated over, don't, signal that, we're just directly defying the Supreme Court. That's usually a bad strategy. But one of the things that it did was not just defy the New York carry case, it specifically disarms religious places of worship by name, right? So we allow secular businesses to determine for themselves whether to allow employees and patrons, to carry. They expressly say, the owner of the property or the lessor of the property can determine whether to allow carry. But if you're a church or synagogue or a mosque, no. If the rabbi says, I want to have protection in synagogue, if the priest says, I want to have protection for the parish, not for you. Right? We're going to condition the exercise of the fundamental constitutional right to gather for worship on the relinquishment of the fundamental constitutional right to armed self-defense. Okay? And that is expressly targeting religious exercise, just like New York did in the Roman Catholic Diocese case, right, where the Supreme Court said you can't do that. We've held that for decades. Now New York is not just only violating, the case that it recently lost on the Second Amendment side, but on the First Amendment side, New York is engaging in exactly the same, type of singling out of religious bodies that it had done during the COVID pandemic. And I think it's just a bad habit, right? And this isn't something, again, like Lukumi was a case where the government's trying to hide what it's doing, right? Before COVID, it wasn't so out in the open. And now it's an open thing. And I think, we're going to be dealing with those effects for a while. I don't want to be a Debbie Downer here. We also got that enjoined very quickly. And it's now not just on Second Amendment bases, but on First Amendment bases, both Establishment Clause and Free Exercise Clause. And I remain pretty confident the Second Circuit on Appeal is going to do the right thing. And if not, that there's upper management that's willing to step in because, it's like a game of whack-a-mole and you have to whack a lot of moles to get them to stop popping up. So anyway, I'll stop it there.
Thank you for that, Jordan. I will add just one comment for those that haven't read Judge Walker's order on that TRO. I think it was one of the first big opinions that came out. I think tour de force is probably the only way to put it before he left to the D.C. Circuit. So I would urge everyone to read it. And as a judge, we've cited or mentioned Lukumi a couple times. I sit in Miami. I can tell you Santeria is alive and well in my district. So I know that case is being followed where I sit. So we're going to move a little bit away from religious liberty issues and some of the civil liberties and transition to property rights. So, Brett, I'd like to turn to you and listen a little bit to your expertise when it comes to public health authority and executive overreach and that impact on property rights in particular. And I'm speaking, as I mentioned in my opening comments, about quite frankly, the unprecedented CDC eviction moratorium. And I know you represented the Alabama Association of Realtors in a successful challenge to the CDC's eviction moratorium in the Supreme Court. So I'm wondering if you could share some of the lessons that you learned from that experience, the potential impact of your very successful challenge on other government agencies in the future, and where you think the Supreme Court may be headed in this particular arena.
Well, thanks, Judge. It's great to be with you, and I agree with a lot of what Jordan just said. The pandemic was a time of extraordinary government overreach. Remember the mandates? The mandates, not just vaccines, but you had to wear a mask, you had to stay at home, you had to work from home. And those were just the mandates. There was also the restrictions that you couldn't have a party, you couldn't congregate in your own home, you couldn't go to the playground, your kids couldn't play baseball, you couldn't worship in some places. You couldn't take a cruise ship out of Fort Lauderdale. And of course, you couldn't, if you were a property owner, you couldn't evict a renter even if they didn't pay you rent. These were all things that I think we all thought could happen in China, maybe Europe, but they came here pretty quickly in March of 2020. And over the last couple of years, I've been thinking, like, how did this happen? Like, how did we get here? Why are we living in a place, where we're supposed to be a free country and we have a government that's supposed to be having limited powers, controlling every aspect of our lives? And I think I have two answers that I'll suggest to you today. I think similar to what Jordan said, separation of powers. The first reason, I think, is our federal Congress has essentially abdicated its lawmaking power to the executive branch. Congress is supposed to make the rules by which we are governed, and it's not. It is delegating that power to the executive branch. That's why you see OSHA issuing a vaccine mandate. That's why you see CDC issuing an eviction moratorium. These are all legislative rules that are major questions that should be decided by our elected leaders. And then the second reason is kind of the nature of executive branch decision-making. There's several people here that have worked in executive branches. When there's a crisis, especially a public health crisis, public officials can't help but use the authorities that are before them. And they will search their codes to find whatever powers they can and to try to meet the crisis of the moment. There's a political imperative to do something. There may be legal imperatives. There may be lawyers saying these are bad ideas, but more often than not, the political imperative outweighs any litigation risk. And that's why you see so many bad decisions coming out of the executive branches. There's just this imperative to take some action, whether it's a good idea or bad idea. And I'll talk briefly about the CDC's eviction moratorium, which is really a misnomer because it's really a rent moratorium. What CDC said was if you're a property owner, whether you're a big corporate landlord or a mom and pop landlord living in Florida, a retiree that has like one rental property, if you have a renter that is making less than $200,000 and they certify that they're suffering hardship because of the pandemic, you can't evict them even if they don't pay. So they can stay in your house rent-free for a year, 2 years, and you can't do anything about it. And CDC's rationale was they were relying on authority in Title 42, which Jimmy mentioned earlier today, which provides broad authority to CDC to take measures that would stop the spread of communicable diseases. And so this is the same authority that CDC was relying on for the transportation mask mandate that was before Judge Mizell, also the no sale order that Florida was challenging. And so CDC's rationale to give their side some play here, their reasoning was, look, if people are evicted and they have COVID, they're going to go live in community environments like with friends or in homeless shelters, and that's going to spread COVID and people are going to die. And so we can't allow that. And so the plaintiffs, who I represented, property owners in Georgia and Alabama, argued, no, this is a major question that Jordan mentioned earlier. Like, your CDC, you're a public health authority, your statute doesn't give you the authority to regulate rental properties or real estate or evictions. This is having a multi-billion-dollar impact on the property market. And so we brought that case in federal district court in DC, and we won. It was great. The federal district court in DC vacated the eviction moratorium nationwide, but then the government moved for a stay because we're still in the middle of a pandemic in May of 2021. And the district court granted a stay of the judgment, striking down the eviction moratorium. So it looked like a Pyrrhic victory because you win a case and the district court says you don't get the benefits of your judgment and the moratorium can just stay in place indefinitely. And so that we went up to the Supreme Court twice. Long story short, the Supreme Court issued an opinion in August of 2021. Great opinion, relying on the major questions doctrine and kind of agreeing with us. Look, this is a major question. CDC does not have the authority to issue an eviction moratorium. They're a public health authority. So that ended the eviction moratorium, and it was a great win for our clients. A couple lessons learned or takeaways from that decision in terms of property rights, Judge. Three quick things take away from that opinion during the pandemic. Number one, public health authorities are not a blank check. I think for the first couple months, maybe the first year of the pandemic, they were. Courts were generally not stepping in to strike down agency action. I think Judge Walker's decision was probably the first, and it was a remarkable opinion. I remember that. But the Supreme Court said, look, public health authorities are not a blank check. Second, they relied on the major questions doctrine. They said, look, regulating property rights is something that is traditionally done at the state level. It's not traditionally done at the federal level. We would expect Congress to speak clearly to something like this, and Congress did not with respect to the eviction moratorium. And then third, I think the court signaled they're willing to step in and protect property rights, not just during the pandemic, but also outside the pandemic. Not just referencing the fact that this is a traditional area of state regulation, but also in the irreparable harm section of the opinion, the court said, look, CDC was intruding upon the traditional, one of the fundamental rights of property ownership, which is the right to exclude. And so I think in other areas not involving pandemic restrictions, you're going to see the court relying on similar rationales to strike down restrictions on property rights. So just to wrap up, Judge, I think we're talking about what does the post-pandemic legal landscape look like, and I just have a couple thoughts to share. I think there are some kind of settled legal precedents, but there's a lot that's unsettled. I think number one, you can't cancel Easter. That was a good one. Number two, no federal vaccine mandate for workers. Number three, no public health authorities regulating property rights. I think those are all good things, but I think there's also a lot left unsettled. I think what should happen in the next pandemic is the federal government needs to stay in its lane. And I think what its proper sphere is informing the public, using its resources and information gathering capabilities to help state and local governments make wise decisions, help individuals make wise decisions about how to protect themselves, how to protect their families, and also using their very broad authorities like Title 42 to prevent communicable diseases from entering the country in the first place. But when it comes to restrictions and deciding what's best on a local level, that's where the states and local governments need to step in and have a proper sphere of their authority under their police power is imposing these restrictions. We all may hate them, but if the people in New York and New Jersey and California and Illinois want to live under a system where their elected leaders can shut down every aspect of their secular lives, then everybody will continue to move to Florida. Although I heard that Governor DeSantis might start requiring visas for people to visit Florida. It's become too popular. So I'm not allowed to stay, apparently. So I think what's the solution, just to wrap up? I think it all comes back to Congress. As I mentioned earlier, I think we need a Congress that will pass the laws that govern our lives, that we don't continue to rely on the executive branch to issue rules that govern major questions that govern society. And I think it's up to the courts to revive what's called the non-delegation doctrine. Not going to get into that today, but Congress can't continue this path we're on where Congress does not legislate and we rely on the executive branch to both legislate and enforce restrictions. So the major questions doctrine is great. It allows courts to, kind of what Jordan said, play whack-a-mole and strike down individual agency actions. But for there to be a kind of a fundamental change, we need the non-delegation doctrine to be revived so we have each branch playing within their specific roles. So, Judge, back to you.
Thank you for that insight, Brett. So now we're going to pivot away a little bit from the legal landscape and focus more on public policy. As Charbo would say, it's the Federalist Society for Law and Public Policy. So we're going to talk a little bit now about, quite frankly, the social consequences. I know that we have a lot of parents in the audience who these comments will resonate with. Karol is going to be sharing some of her thoughts on educational policy and her personal experience. Quite frankly, as a wife and a mother of three living in New York, you heard from Jordan a little bit ago about some of the policies in New York, who ultimately chose to relocate. We didn't require a visa. She made it down here to South Florida with her family. And as I stated, I know many of us with children have hopefully recovered from the days of remote learning, if you remember what that was like. And Karol has written, and I urge you to go read many of her columns, several compelling pieces on learning loss during the pandemic, which we're just starting now, I think, to fully understand as we look back at the policies that were implemented in our schools throughout the country. So, Karol, can you share with us your insight, your experience with the policies implemented by the CDC, mitigation tactics like masking and mandates, and the impact on the educational system, and your personal story on becoming a Floridian?
Sure, yeah. Thank you so much to the Florida Federalist Society for inviting me. I wasn't sure I belonged on a panel with such accomplished people in the legal field, but my friend Charbel Barakat insisted that that would be okay, so we'll see. Charbel and I actually met playing in a long-time poker game in New York, and I'm only telling you that to sound cool. So, secret game, yeah. I actually used to attend a lot of Federalist Society events in New York in my 20s, and not just because I thought that was a good place to meet a gainfully employed right-of-center man. I learned a lot about the laws that shape policies around me, and I'm grateful to the Federalist Society for giving me that base of knowledge. Having said that, I'm aware, as I'm sure you all are too, that people generally don't give a lot of thought to the control the government has over our lives and whether or not that control is lawful. I spent a lot of time criticizing politicians and bureaucrats in my work, but pre-COVID, I would have said that the CDC was necessary, health agencies don't have political interests, and Andrew Cuomo, not a bad governor. I took COVID very seriously. In February 2020, I posted a list of supplies on my Twitter and Facebook, and several friends told me I kept them in toilet paper through those first few months. I should say here that in March 2020, I think I was among the first to write that schools should close. I mean, whoops. My husband had stopped going to work, but my kids were still in school every day, and it made no sense to me. So that's one of the definite mistakes I made during that time. 2 weeks to slow the spread sounded good. And as that 2-week period turned into 2 more, and as there was no plan whatsoever to get the kids back to school, I knew I had made a terrible mistake. And I think it's very important to own up to our mistakes. And so I've written and talked about mine many times. So that's why I think it's so unacceptable that none of the people responsible for the atrocious COVID policies and all the things that we've heard about today have been held accountable or apologized in any way. The CDC has been an abject disaster through this process. I actually have a writer friend who's an anarchist, and in March 2020, I asked him, his name is Michael Malice, maybe you know his name, but I asked him, what would an anarchist society do in this situation? Like, don't we need to talk to other governments to handle this? And now I realize it absolutely did not help whatsoever to have the CDC. In fact, I think that they really caused a lot of damage, and through their just being wrong about so much, but also through their constant reversals on what they were suggesting that we do. One particular moment that sticks out to me was when the CDC head, Rochelle Walensky, said that pregnant people should get the vaccine. And then a few days later, the CDC walked it back to say they could get the vaccine. Now, I know I'm in a room full of lawyers, and actually I was a paralegal for pharmaceutical companies right out of college. So I know that one word, should or could easily be a 2-hour debate in all of your offices. But that this happened at the CDC showed how deeply unserious they were and how they couldn't be trusted to get clear information to the public. Walensky also said at one point that schools could open even without teachers being vaxxed. And then a few days later, the White House said that she had said that in her personal capacity because that didn't fit in with their policy goals. So our politicized health agencies were taking direction from the White House, and who the White House was taking direction from were generally leftist activists. They kept changing their guidance to fit in with what their political allies wanted. So for a while, they recommended double masking. Who remembers that? I would love to hear one person at the CDC stand by that recommendation today. We know it was pointless. We know it had absolutely no effect on spread, and yet it was something that came officially out of our health agency. But far more sinister, they allowed teachers' unions to rewrite policies that kept children out of school. And they had an absurd 6 feet rule where the kids had to be 6 feet apart in school. And, the CDC covers for themselves when they say, oh, this is just a suggestion. This is, we're not saying you must do this. But all of these states, including New York, where I lived, used the CDC guidance to do exactly what they were suggesting. So it didn't mean that their guidance could be just overlooked because nobody was overlooking it. So that 6 feet of space between kids in classrooms was, I think we're going to look back at it as being about as useful and effective as the idea that kids could hide under their desks during Cold War nuclear attacks. And then they wanted to change it to 3 feet, but Randy Weingarten, the head of one of the biggest teachers union, if not the second biggest, said no, and then they did what she said. And it was a travesty, and absolutely no one at the CDC or the Biden administration has been held accountable for any of this. And it wasn't just the CDC that got in on doing what the Biden administration told them. I get a lot of why do you hate Anthony Fauci so much? Why are you so angry with him? He was just doing his best. And I think, if he was doing his best, he's horrible at his job. Let's just say that. But even if you believe he was doing his best, in February 2021, when schools had been open in Florida for a while, but not open in places again like New York City and San Francisco and Chicago and other places, Anthony Fauci said that Biden's spending plan had to pass in order for schools to open. I mean, can you imagine if a top health official just directed you to support Republican policy in order for your children to go to school, and what that story would be like? And yet he has this glow where he was this saint who saved us during the pandemic. And if that's saving us, what the death numbers we've had, wouldn't want to see what we would have done without him. I should say here that I was born in the Soviet Union, and I came to the US when I was a small child. I grew up in Brooklyn, and the enforced conformity around the COVID moment was really familiar to me and really resonated with what I had been told my whole life my family had experienced in the Soviet Union. It was like, obviously, I'm not saying America is like the Soviet Union. I feel like I have to qualify that. But there were so many times where my parents told me it wasn't specifically the government that was shutting down your speech. It was your neighbors. It was the pressure to fit in. And I saw this in Brooklyn in a lot of different ways. If you wanted schools to open, you wanted teachers to die. And if you tried to speak out about it, you were not only shut down, they might call your job. And this happened. People got fired for wanting schools to open. The open defiance that Jordan mentioned, I saw that in our politicians. They were like, you must mask all the time. We never mask. They never masked. Cuomo, I'm not even sure he owned a mask. I don't think Kathy Hochul does either. And yet, to us, it was constantly like, you have to do these things that we will not be doing. Gavin Newsom, obviously, going to French Laundry was a very popular example. But that was also, it felt very Soviet to me, where the leaders don't have to do what the rest of us are doing. COVID hit when my 3 kids were in 4th grade, 1st grade, and pre-K. And the 4th grader and the 1st grader were actually kind of okay. They were on remote. The pre-K, obviously, just him going into kindergarten in 2020, September of 2020, and the schools being on a part-time basis in New York City was fading and fast. He was behind a mask, impossible to understand 5-year-olds at the best of times. And behind a mask, it was like, he just wasn't getting through it all. I remember one of the last moments of my husband and I deciding to leave New York, they showed us on Zoom his class, doing some kind of performance through masks on Zoom to us. We're at home and they're in the classroom. And it was like, why are we hearing? They can't understand each other, and why are we watching this? Because I don't know a single word that they're saying. So the first few months were a haze of banana bread making and watching Little House on the Prairie, which it holds up. And just generally just enjoying our time together. My husband grew a beard, took up gardening. We could have easily leaned in to being the COVID forever people. Easily. We were living in Park Slope, Brooklyn, which is super left, wealthy part of Brooklyn, where everybody was just loving this. And that could have been us easily. But I had grown up in a different part of Brooklyn. I grew up in Flatbush, which was a really poor area. And all of my friends who had survived Flatbush, made it out, not died of drug overdoses, not, been killed. They owned small businesses. They were plumbers. They were refrigeration guys. They were car service drivers. And I saw that none of my Park Slope neighbors cared at all about them. Like, not at all. Did not care what was happening with them. Stay home, save lives, that was it. And they didn't understand that so many people couldn't even stay home, that there were people who had to go to their jobs, that the Uber Eats did not arrive at your door via magic. And then summer 2020, obviously, there was the Marches for Equity. And then in September, the private schools all opened, but the public schools didn't, and no one marched at all. It broke me. It really broke me. I loved New York. I had never imagined living anywhere else. I was Brooklyn till I die. That's a line from a rap song. And, it also changed me politically because I was a lifelong conservative. Look, you're not born in the Soviet Union, get to New York and decide to be a liberal. It just doesn't really happen that way. But, a lot of people pushed back on the things that I was writing where I would just say, like, the governor is responsible for opening schools. Like, get those schools open. And they would say, oh, aren't conservatives for local government? And now I don't consider myself a conservative for local government. I am a conservative for the individual and against all tyranny. I don't care if it comes from the local or state or federal, all tyranny. And so Florida has been the freedom promised land. It really has been. And I've written a lot about how grateful we are to be here and how my kids are blossoming and they're just thriving and doing so great. We got here a year ago. They went to school without masks. My youngest, who I was most worried about, is doing fantastic. Total Florida man, never wears a shirt, plays 17 sports. So I have co-authored a new book called Stolen Youth, and it comes out March 7th, but we actually have 20 copies for me to sign after this. You're the actual first people who are able to buy it if you would like to. And it's on all the ways that woke culture targets children for indoctrination. But we included a chapter on COVID, which is looking back instead of kind of looking forward and current, right? All these woke things are happening in your schools or at the pediatrician's office or in your library and publishing houses, et cetera, now. But COVID is, maybe in the rear view. But we needed to write that down because it was a time where the institutions enforced the kind of conformity that wokeness demands. And freedom is a running theme through our book. A win is a family who is free, is something that we try to get across in this book. And thank you to the Federalist Society for fighting for those freedoms.
Thank you for that, Karol. So we have just about 10 minutes or so, and I wanted to see if we had anyone in our audience that wanted to ask any questions of our panelists. I think that if there's one overarching theme we've all seen from all of our fantastic speakers today, I think Karol hit it on the head as she finished her remarks, that it's about not forgetting and learning. I mean, I think that it's very easy in the haze of COVID and the hangover of COVID to forget some of these moments. I'm remembering them just by Karol talking about them again because we forget it. We don't want to go back to some of those experiences, but it's important moving forward. As Brett said, some of the lessons we're going to learn is to take this moment and reflect on that and try to remember those lessons, as important as they were, should we be faced, heaven forbid, with something as significant as another pandemic. So with that.
Good morning. Is this on? Can you hear me?
I don't think so, man. Yeah.
My question is about the PPP loans. And I recall the discussions when those were being argued in the legislature and whatnot. And it seems to be, I remember that they were anticipating 10 to 20% fraud. So if it's actually 1%, that's very encouraging. I don't know that I believe that 1%, but I remember that being thrown about. But one of the, I guess, mechanisms that they used to control the fraud was the loans were originated at banks, and the banks would have relationships with these customers. So my question is, do the banks have any liability or even consequence for the fraudulent loans?
Jay, go ahead.
Yeah, I can tell you. The idea of bank relationships with the customers, at least from our experience and what we see, is pretty much a fantasy because a gigantic portion, an unbelievably large number of the loans actually weren't created through banks. They were created using fintech companies. And that's been one of the biggest challenges and problems, is that fintech companies were literally just turning these things over for the little bit of fee involved in the processing, so that there really was not that relationship. And because the loans were small business, individuals, and nonprofits, a lot of the bank relationships weren't there, at least from the cases I've handled. And that's really all I'm allowed to talk about is our work here. I can't get into the policy of this. But so there was not this great relationships between the banks and the individuals that you would expect to see in a normal business operation. You had people, frankly, sitting in their homes. The fraudsters that I encounter were sitting in their homes. They were stealing identities. They were going online. They were applying for loan after loan after loan on their phones. And so we would see one IP address applying for 50 loans. So you know the chance of that one IP address applying for 50 legitimate loans is really low. If I was going to, from my perspective, as a person who investigates and prosecutes fraud, if there's ever a scenario whereby there's some sort of spontaneous government program, which is just a scary thought, right? So you shouldn't even say spontaneous government program. But to the extent there is that ever again, the best way I think that you really need to address it is to invite into the room at the design, literally in the forms that need to be filled out, the processes that need to be gone through to get the fraud, the loan proceeds, is to make sure that the individuals who are applying for the loans on the face of the loans can see, I'm going to have a problem if this is a lie. I'm going to have a problem. So, you have ID, photo, tax returns, but that just wasn't the case with these, so that you don't have the SBA data being crossed with IRS data, being crossed with DOL, Department of Labor data, so that you could look at this and immediately throw out the red flag loans, and then have those people that are flagged have to make one extra step to personally appear or personally show up to get their money. That's the best way to do it. You have to put the blocks on the front side. By the time you bring it to me and the tray's been thrown off, like I said, by the time it comes to us, it takes months and months and months of subpoenas, requests for information to the IRS. It's a very cumbersome prospect for us to build a case, to charge it with a complaint and then an indictment before we ever get to Judge Ruiz. So by the time he sees them, a great deal of manpower has been expended. Much better spent on the front side, saying, making it easy for a legitimate loan to be pursued, but making it very difficult for an individual to create all of the necessary paperwork for fraudulent loans to be submitted. And that should be in any government program, and that's just based on my work here in the Middle District of Florida for the last 25 years.
Thank you, Jay. Rocky, did you want to?
Thank you,
Go
Judge.
ahead, of course.
Good morning. My question is about the issue of freedom, and not just the freedom for individuals, but freedom of businesses. First Amendment, rights of association, the Commerce Clause, particularly for businesses that function in many different states. During COVID, we saw many different mandates at the federal level, at the state level, county, city, conflicting, very confusing. And now we're seeing, on the flip side of that, prohibitions on what businesses can do if they want to promote certain kinds of practices, like requiring vaccines or certain other requirements. They get could be a violation of civil rights laws of a state, or even if they want to do certain trainings of their employees. And I'd love to get the panel's take on the balance between being a champion for liberty for individuals, but also being a champion of liberty for private enterprise.
Brett, you want to try that one?
Sure. So my first thought is, reaction was, so during the pandemic, my law firm tracked for all of our clients, all the restrictions state by state on businesses. And we had like a 300-page chart that was constantly updated like hour by hour. And we would send it to clients. I don't know how, if you were a business owner, you would comply with all the the multi-layers of restrictions, like in California, if you had a business. You had the federal level, you had the state level, you had the county level, you had the city level. It was crazy. I don't know how businesses did it. My other reaction was, we talked about some cases that were successful, and I think it's like pretty clear the government can't do these things in the future. But for the most part, I don't recall any kind of state level restrictions outside of the religious liberty context that were struck down as violating like state constitutions. There may be a couple examples I don't recall. And I think during the first year of the pandemic, courts were very hands off. They did not want to interfere with public health authorities when businesses were bringing kind of freedom of commerce type challenges. So I think just looking at the case law and like what I could like prove as a lawyer, I think it's very difficult for a business to push back on these types of restrictions unless they cross the line and violate a specific constitutional provision.
And to that point, Brett, I think one of the most underdeveloped areas of the law during this whole thing is state separation of powers issues, right? Because we saw a lot of restrictions. I mean, at the federal level, we saw, some litigation about whether agencies had exceeded the bounds of their authority delegated by statute. We saw developments in the major questions doctrine to sort of push back on agency overreach. But I don't, and it may just be my ignorance, but I am not aware sitting here today of a case that dealt with a significant, state separation of powers issue. And what we saw in a lot of these mandates is it was exercises of, purported executive authority that looked a bit more like exercises of legislative authority. The sorts of, careful policy judgments that you would think you would want to have deliberated in a bicameral legislature and presented to the executive, right, that govern private affairs and private conduct in a way that really touches on people's lives to a very significant degree. And typically, in our system, and this is true of the states, not just the federal system, it is the executive's job to enforce the laws, but in terms of determining what the rules of private conduct are, what the rules of commerce are, what activities you're allowed to engage in and to what extent, I mean, that's a quintessential legislative determination. And we had a lot of executive officials. We had mayors, we had county commissions, we had governors, rolling out very voluminous, sets of regulations to govern, private conduct. And, I kind of do wonder whether, in some instances, and again, I'm not an expert on every state's, allocation of authority between the different branches, but, I kind of wonder whether some state separation of powers challenges would have had some purchase, at least, with respect to some of these policies that we saw.
Thank you.
Thank you. Question? Yeah.
Good morning.
Morning.
My question's on what can be done proactively. It sometimes seems to me that the side of freedom and liberty is reacting to government overreach, to tyranny. I've seen it with the war on terror. People start distrusting the intelligence agencies for their violations of individual liberty, and we now see it with the pandemic response and the various government overreaches there. I think it's going to happen again. We can all bet that the government's going to step over its bounds. Maybe it's the climate crisis response, or who knows what they're going to do. But what can we do ahead of time as opposed to responding?
I don't know, maybe follow the Constitution, crazy. I don't have much, I don't know. Not really sure what we can do.
I mean, I'll take a stab.
Yeah.
First, I think it's electing the people that we want in power during the next crisis, that we trust to make these decisions. I think it's reminding them what happened and the consequences of those policies. I think for judges, and there are many judges in the rooms, I think it's a commitment to the rule of law, whether we're in a pandemic or not, and making decisions based on the law and not, hyperbole or fear of criticism. So it's going to be hard. I think I think we'll continue to see federal overreach, state overreach during the next pandemic. And I think people forget, I mean, the last major pandemic, it was, none of us were here, like 1918. And so, hopefully we don't have another pandemic like this one in another 100 years, but hopefully lessons will be learned.
Thank you.
Thank you.
Thank you to you all. Thank you to everyone for coming. I have questions for each of you, but in the interest of time, I have a question for Brett because it's the one that's been on my mind the longest since almost the beginning of the pandemic, and that is whether there have been any Fifth Amendment takings claims brought by landlords in rising from the CDC eviction moratorium, and if not, why not? Because I haven't heard of any.
Yes, there's one we're following very closely in the Court of Federal Claims in D.C. That's where you have to sue the federal government for money damages. There's a case brought by, I think it's the National Apartment Association. They lost in the trial court. They're on appeal in the federal circuit. We filed an amicus brief in that case, so we're following it very closely on behalf of kind of all property owners. And the issue in the case is whether it's interesting that the lower court said there's no claim for money damages against the CDC, essentially, because they acted beyond the scope of their authority because the Supreme Court said it was illegal. And the plaintiffs were arguing, no. Like these government agents were acting within the scope of their employment. Whether they were acting illegally doesn't really matter for money damages purposes, but it's a case we're following. And at the state level, I know that I think pretty much every other takings claim against a state equivalent eviction moratorium lost. So this is a kind of a cutting edge area of the law.
Thank you.
Thank you. So with that, I think we're a few minutes over time, but I think we should all thank this fantastic group of panelists here for their contributions.